This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. If you or someone you know is looking for a qualified collaborative professional, please visit www.collaborativepracticeflorida.com and the Find Help button to locate a trained collaborative professional in your community. I'm Catherine Eaton, a collaborative family law attorney and a member of the Florida Academy of Collaborative Professionals. Today's guest is Adam Cordover. Adam is also a family law attorney who practices collaborative family law. He is the co-editor and co-author of an American Bar Association book on building a successful collaborative family law practice. He is a member of the board of the International Academy of Collaborative Professionals, recipient of the inaugural Visionary Award of the Florida Academy of Collaborative Professionals, an FACP accredited collaborative professional, and has trained attorneys, judges, general magistrates, psychologists, marriage and family therapists, accountants, and financial planners throughout the United States, Canada, France, and Israel on collaborative practice. Adam has offices in Tampa, St. Petersburg, and Sarasota, and he represents clients throughout the state of Florida. His website is familydiplomacy.com.
Well, thank you so much.
And that's why you're here, because you have done it all as far as collaborative practice goes. And we would like, or in asking you to share, what is the role of the collaborative lawyer?
Yeah, great question, Catherine. Thank you so much. So there's a bunch of different roles of the collaborative lawyer. So first off, we are there to be by the side, to give advice, to be by the side of the client throughout the process and ensure that they are informed about whatever decision they make. We're there as an advocate to make sure that the interests of the clients are addressed. But there's also somewhat of a little known role of the collaborative lawyer as well, where they're as an achiever to achieve the goals of the client at the end of the day. And let me give you an example about what I mean by that. A lot of people choose the collaborative process because it tends to be a private process. The privacy is really important to them. And so one of the things that we do is we look to determine what is the best way to file a divorce at the end of the day once an agreement is reached, so that that goal of privacy can be upheld. A lot of people don't realize that you can file a divorce anywhere in the state of Florida. It doesn't have to be in the county in which you reside, so long as the spouses are in agreement. And so there are certain places out there where we can minimize the amount of sensitive information that goes in the public court file, so you can still maintain your dignity, maintain your privacy, and be able to move forward in the future with confidence.
So how should someone expect their collaborative lawyer to act? What's different from a collaborative lawyer versus if you hire an attorney and you end up litigating?
Yeah, so a lot of people come into a lawyer's office and what they know about divorce lawyers, they've seen from Kramer versus Kramer or War of the Roses. And so they expect people to come in pounding the table and yelling and do all that type of stuff. Well, that might have worked in prior generations of divorce, but it's not what people today find is most helpful. In fact, it really didn't work in prior generations of divorce. And that's why so many people are looking for something different. They don't know what to expect, but they know they don't want what their parents went through. They want something different. So part of what we do is we try to make the collaborative process as non-adversarial as possible. Traditional divorce looks at spouses as opposing parties. We don't look at it that way. We look at the clients as a family unit who are looking to dissolve their marriage, make sure that the kids don't get stuck in the middle and are able to move forward for the rest of their lives. Me and the other attorney, we're not opposing counsel. We're there as teammates, on the same page, looking to find a resolution that works for both clients, while again, individually advocating for our clients in a way that's different than happens in court. We're not making arguments, but what we're doing is trying to find that space where both of the clients can find an agreement that they can live with and live up to, and make sure that their kids are okay at the end of the day.
And besides the attorneys, there can also be a team with a financial neutral or a mental health professional. What's the advantage of having additional team members?
Yeah. So many people who hear that there are additional team members who will oftentimes be part of the collaborative process, they get really scared because the first thing that comes to mind is, well, it's got to be a whole lot more expensive if you're bringing on additional team members. And let me be specific about who we generally bring on. First off, we bring on a facilitator. That's somebody who is a licensed mental health professional who is usually a communication specialist. They are knowledgeable in things like childhood development and communication between clients. So that's number one. Number two, there's oftentimes a financial professional, somebody who helps analyze the finances of the spouses, who is there to help both of the spouses get on the same page and learning what are the finances that are there, what are the finances of the household that need to be divided and dealt with, and provide some options. So again, a lot of people hear that and they the first thing they think is, well, that's got to be expensive. Well, let me tell you why it's actually usually less expensive when you bring on these professionals. Number one, what we find is that divorce tends to be a trauma. It is very much like a death, the death of a relationship. And so people react to this trauma similarly to how they act to other traumas. It's usually either a fight, flight, or freeze response. And the things that really get a divorce process stuck are not the legal issues, it's the emotional issues that are swirling around and just either urging somebody to just fight back or run away or just freeze in place. And so the facilitator is there to cut through that emotional clutter and help the clients process it so that they can make agreements and reach a resolution and move forward with their lives. So it actually tends to speed up the process and make it less expensive. So that's the facilitator. Another big reason why divorce cases tend to get stuck or to last a long time or to be really expensive is because it's common in most marriages for there to be a division of labor, with one spouse being more in charge of the finances and the other spouse being more in charge of the household or children or other related things. And even if throughout the marriage the spouses have met together to talk about the finances, because of that division of labor and because of the trust that was developed during the relationship, the spouse who's more familiar with the finances is being relied on by the other spouse to make those decisions. And so the spouses may get together with their books and just so both supposedly have an understanding about what's going on. But again, the spouse is not familiar with the finances, usually isn't paying a whole lot of attention, and is just relying on the other spouse. Now, so what happens when you get to the point of a divorce is a spouse just says, I don't understand the finances. And quite frankly, excuse my language, I'm afraid that I'm going to get screwed because I don't understand the finances. And then the other spouse says, well, what are you talking about? We went through the books every month or every quarter, and without realizing that the other spouse was just relying on them. So this is where the financial neutral comes in. The financial neutral helps make it so that both spouses are on even footing, and that the spouse who wasn't as knowledgeable with the finances can make an educated decision when it comes to how the assets and debts are going to be divided, how different support options are going to take a look. And so, again, this shortcuts that thing that we saw all the time in divorce cases before we were using financial neutrals, where one client just could not make a decision because they were afraid that they were going to choose and something that would affect them for the rest of their life, and which was going to be negative for them. So, so that financial neutral can be just totally essential in helping reach an agreement.
Can you talk about the generalities of the cost, the value of a full team versus bringing in outside allied professionals and other benefits of the collaborative process?
Sure. So first off, let me just put the statement out there. It's not cheap. Collaborative divorce is not cheap. Divorce is not cheap. And so when people are oftentimes come in and they, and it makes sense, they haven't worked with divorce lawyers before. Some have, but most people have not. And so they may be surprised that there is a cost. In many ways, we like to think of it as an investment, because the investment can go one of two ways. You can invest in learning to fight with your spouse and ultimately having a judge decide, and then knowing that for the rest of your lives, you're no longer going to be married. But if there are children's issues or support issues, the way that you learn to resolve that is to continue to fight and then continue to bring it to court and ultimately incur many, many more expenses later on. As opposed to the collaborative process, where we're teaching you to resolve the issues in an interest-based way, to help figure out what are the other spouse's interests, what are your interests, and how you can move forward. But it's not inexpensive. And I've had collaborative matters which have been total expenses, everybody paid for as little as $10,000. I've had collaborative cases which have been in the six-figure area. So again, I just want to create realistic expectations. Just because it's called collaborative divorce doesn't mean it's cheap. It's not, and you shouldn't expect it. That being said, there are some things that you as a client can do to make it less expensive. So, for example, one of the biggest things would be to kind of keep the big picture. Don't fight about the small things. If you're spending thousands of dollars fighting over a $200 lamp, then it's going to be more costly than you're going to like. And unfortunately, I've seen that before. So I counsel every single one of my clients, don't fight over those small things. Just really keep an eye on the bigger picture. What are your most important goals? Your financial security at the end of the day, that your kids are okay, that they're going to be healthy and well taken care of. Those things which are really important. Another thing to know is that the simpler your matter, and the simpler your estate, the less expensive it's going to be. The more complex holdings that you have private business or a lot of different big portfolio in stocks and bonds, or if you have children versus no children. Well, these are just different factors that could make it more or less expensive. So that range that I told you, it's a big range, and those are kind of the extremes. But it's important to know that there is a cost associated with it. Certainly, I find it tends to be, in many cases, less expensive than if you're going to be fighting it out in court, especially if you consider not just the divorce itself, but fighting it in court once the divorce is over. And when people, again, go through the litigated traditional divorce court process, that's usually not the end. They're usually fighting for many years to come. Here, we try to shortcut that and prevent it. So that's the issue on the cost. Before I get to the team, just I want to check in. Catherine, did I answer that question?
You absolutely did, so thank you. And
Oh,
I'm just going to follow up with how long does the collaborative process usually take?
so that's a great question. I was telling folks earlier a few years back that that generally it would take about 3 to 4 months. I found during COVID that that people were very stressed out, that there was a lot of tension and a lot more conflict, and so I'm finding nowadays it's actually getting a little bit better now, but at least over the last 3 years, I found it closer probably to 6 to 8 months. Um, but your individual case could be much shorter or take much longer. The shortest collaborative matter I ever had was over 2 weeks, 2 meetings over 2 weeks. The longest collaborative matter I had was probably a year and a half. So again, those are just kind of the extremes, the ranges. By the way, I don't litigate anymore. Catherine, you mentioned that in my introduction. When I used to litigate, it was fairly common for cases to drag on for a year, 2 years, 3 years, even 5 years or more. So the collaborative divorce process does not tend to be a short process, but it does tend to move more quickly and more efficiently than the litigated process. So yeah, and then when it comes to the team, um, I have a view that is maybe a little unorthodox compared to some other collaborative attorneys out there. So different attorneys have different views about what you need for a collaborative team. I talked about the basic model, the model that is most often used in Florida, which is that each person has their own separate lawyer. There is a neutral facilitator and a neutral financial professional, and that's what I use in the vast majority of my collaborative matters. At the same time, I think it's important for us to recognize that not every family fits in a cookie cutter format of collaborative practice. And there are actually other types of models of collaborative practice that might work for a particular matter. So, for example, if it's a short-term marriage and not a lot of assets and no kids, maybe the clients just want the knowledge of knowing that their attorneys, they want individual advice, but they want to know that their attorneys are not going to be used to fight in court. So in that particular set of circumstances, it may make sense just to use a lawyer-only model of collaborative practice. On the other hand, it might be that there is a need for more help than is provided by the traditional model that we use in Florida. So, for example, I've been involved in collaborative matters involving severe mental health disorders, involving domestic violence, involving addiction and other things. And sometimes in those cases, it makes sense, instead of having a neutral facilitator, which again is that licensed professional who is a communication specialist and helps with the children. When you're dealing with some of these more difficult situations, sometimes the clients need their own individual coach rather than a neutral facilitator. And by coach, I mean also somebody who is a licensed mental health professional who has those specialties, but really the clients need them aligned and on their side rather than acting in a neutral capacity. Again, especially if there's involving issues of domestic violence, I think that's an important case because sometimes it can be tough for a mental health professional to be a neutral in those circumstances. There's also other types of models of collaborative practice that we use. So there is the type of using a mediator instead of some of the traditional types of neutrals. It's actually called collaborative mediation. So where each person has their own lawyer. The lawyers are there solely for the purpose of reaching an out-of-court agreement, and you have a mediator who may be a lawyer, may be from another profession, to help the clients reach an agreement. So what my practice tries to do is customize the model of collaborative practice that we use to fit the needs of the clients in front of us. And so it tends to be flexible. There may be other professionals who are needed as part of the process.
If someone's looking to, if somebody's in the middle of a divorce or starting a divorce, how do they start the collaborative process?
Yeah, great question. I think first off, you need to seek an attorney or other professional who is collaboratively trained. You could do that at the starting at the website of collaborativepracticeflorida.com. That's the Florida Academy of Collaborative Professionals website. Or you may have a local practice group that you can reach out to, and that's an organization of attorneys, mental health professionals, and financial professionals who do this type of work. So the very first step is to find a collaborative professional and speak with them. By the way, I was about to say find a collaborative professional in your area, but in the days of Zoom, it doesn't actually even have to be in your area anymore. And so many of us have statewide practices. And you mentioned during my intro that I've got offices in Tampa, St. Pete, and Sarasota, but I truly have a statewide practice and do the magic of Zoom, and so I'm helping people out. So just find a collaborative professional, have the discussion with them, learn about the collaborative process, and then they can help you figure out how to get your spouse and another attorney on board to begin the collaborative process. But it's also important to know that a lot of people, so collaborative divorce has become a popular term. And a lot of people, a lot of attorneys especially, are talking about collaborative divorce. They may not be talking about it in the way that it is intended. It's a statute. So collaborative divorce is a legal term. It has a specific meaning in the state of Florida. It's a process where each person has their own lawyer, and the lawyers are there solely for the purpose of reaching an out-of-court agreement. Unfortunately, I've stumbled upon some websites of people talking about collaborative divorce, litigators talking about collaborative divorce, and I've even seen a phrase like, in order to have a successful collaborative divorce, you need to be prepared to litigate. And that's not really, if somebody's saying that, I don't think they quite understand what the collaborative divorce process is. So I think there are some simple questions that you can ask to help understand whether the lawyer you're talking about is a true collaborative lawyer and understands the collaborative process. So first off, when did you go through your 14-hour collaborative divorce training? If somebody says, well, I didn't take a 14-hour course, but I took a 1-hour course on collaborative process, well, they're not trained. They probably don't know what the collaborative process is or how it works. And the International Academy of Collaborative Professionals has set out standards for these trainings, again, for courses that last at least 14 hours. And the FACP, the Florida Academy of Collaborative Professionals, has similar standards. So number one, when did you take your 14-hour introductory collaborative training? Number two, ask the question, well, how many collaborative matters have you actually been involved in? And I would ask this very directly. If the person cannot respond, then it may be that they haven't had any collaborative experience, which may be okay. You know, especially you may actually get some value in that, so long as they've had the 14-hour training. But that is at least, I think, an information point you're going to want to have. If they pivot the question and answer, well, I've been involved in hundreds of divorces or thousands of divorces, well, make sure that they answer your question, because you're not asking them how many divorces they've been involved in. You're asking them how many collaborative matters they've been involved in. So you should ask that question. Another thing that you might also want to check in is whether that person is a Florida accredited collaborative professional. This is a designation by the Florida Academy of Collaborative Professionals, where there's an application process, and the professional has to meet certain minimum standards in order to be that. Now, again, ask that question directly. And you may very well hear a response like, well, I'm a board certified marital and family specialist. And that's an important designation. That's a very well respected designation, but that's not geared towards collaborative practice. That's more geared towards litigation. And the skills that you need in the collaborative process as a negotiator, as somebody who is focusing solely on out of court dispute resolution, those skills are very, very different than the skills that you need going through litigation and fighting in court. So, so if somebody says I'm a board certified marriage and family lawyer, that's impressive. That's important, but that doesn't answer your question. And make sure to ask that question: are you an accredited collaborative professional?
Adam, I have a question for you.
Yeah.
That how did you get started in collaborative, being a collaborative lawyer, and decide to stop litigating? What happened?
Yeah. So first off, I had, and thank you for that question, Catherine. So I had I had a practice where I rented space from another attorney. Her name is Jorn Jenkins, and I was a young lawyer then, and you know, she was telling me about a introductory training that was coming up in collaborative practice, and I'd never really heard about collaborative practice or collaborative divorce. And you know, I said to her, well, that's, you know, wonderful, but you're talking about a 2-day training. And quite frankly, I'm already a nice lawyer. I already negotiate nicely. So I don't need to take away 2 days away from my business and not be able to bill and all that. But she convinced me, no, it's not just being a nice lawyer. There's a process involved. And this is going to be really the divorce of the future. And she's very convincing, and so I ended up going to the 2-day training, and it really opened my eyes that that the litigation that I had been doing was within an adversarial system that pitted spouse versus spouse and parent versus parent. And the collaborative process, as I mentioned before, was a non-adversarial way to not pit folks against each other, but to help them resolve things and move on. And so the more collaborative work I started doing, the more I started getting frustrated with how inefficient and how argumentative and just quite frankly, how stressful the litigation work was, both for the clients and for myself. And so I made a decision in 2015 that the litigation work no longer aligned with my values. And so at that point, I came up with a plan about how I would transition my practice from including litigation to not fighting in court anymore, to not including litigation work anymore. And so I implemented that plan, and the day that I stopped taking litigation work, I thought to myself, oh crap, what have I just done? Because I was wondering, you know, is it possible that I could still pay my bills and do my work? And what I really found is that people began, I found that people were seeking out something different. They had, again, seen what their parents had gone through or what their friends had gone through, and they don't know what they wanted to do, but they knew that, you know, their marriage wasn't working. They need to figure out how to move forward, and they wanted to just divorce differently. And I found more people were seeking that out. I went to speak at different events, got involved in different organizations, and I found that fortunately my practice has just grown since 2015. I've got just my staff is growing as well. I was spending actually Tuesday onboarding a new attorney into my practice. And again, the entire practice is non-litigation. We don't fight in court. So though I don't make as much money in any individual divorce case now as I used to when I was litigating. What I found is that my clients tend to be happier at the end of the day. Maybe not happy, they're still going through divorce, but at least more appreciative than when I was fighting in court with them and for them. And so they're much more likely to refer me cases once the matter is over and leave just the most wonderful reviews on different websites. And I've also found the more work I do, I think other lawyers appreciate working with me too. So I'm getting more and more referrals from other attorneys who are representing one spouse, who are providing my information to the other spouse to help move things forward. So that's been my journey, and I feel grateful every day that I can help clients out, I think in a better way, and hopefully make sure that kids, especially when there are children, they get upheld, their best interests are being focused on, and to try to keep conflict as minimum as possible. That's my story.
That's a great story. Thank you.
Thank you.
And just one more follow-up. You mentioned practice group, and I know you're in the Tampa-St. Pete area. Will you please explain what a practice group is? What does that mean?
Yeah, so a lot of people have heard about bar associations like the Florida Bar, which is what regulates lawyers in the state of Florida. There's oftentimes local bar associations. For example, locally, there's the Hillsborough County Bar Association and the St. Pete Bar Association. That's just a place for lawyers to gather to learn about different areas of the law. Well, in collaborative practice, there's something similar to local bar associations. They're called collaborative practice groups. And what they do are they're a gathering of attorneys, mental health professionals, and financial professionals, and others who want to help people go through family law and other issues in a better way. And so typically it involves education, helping people figure out how to do better at the work that they're doing. It involves networking, getting to know the professionals before you work with them. That hopefully will make it, once you're involved in a case together, smoother to be able to work together. And also, oftentimes they're involved in public education, helping let professionals, let potential clients know about the collaborative process, and that is an option that is available to them. I'm a member of two local practice groups, the Next Generation Divorce Practice Group and the Tampa Bay Academy of Collaborative Professionals. Both of them are just wonderful groups. They have slightly different focuses. Next Generation Divorce is there to help make collaborative practice more accessible to more people. And Tampa Bay Academy of Collaborative Professionals is more helping to help with the equality and the learning aspects of collaborative divorce. Not that Tampa Bay doesn't care about accessibility, or that Next Generation Divorce doesn't care about quality, but it's different focuses. And I found those two perspectives help me in helping to offer families more ways to do collaborative practice in a better way.
Thank you. Thank you for all the information. We appreciate you sharing.
Yeah. Hey, Catherine, thank you so much. I really enjoyed it.
This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. If you or someone you know is looking for a qualified collaborative professional, please visit www.collaborativepracticeflorida.com and the Find Help button to locate a trained collaborative professional in your community.